All right, welcome back. Yes, we will start off talking about elections this morning. Mr. Mike Igini joins us today. He's the former resident electoral commissioner for INEC in Akwa Ibom State. Good morning, and thank you for joining us today on the program. 94 million odd voters, but, you know, when that was released after the initial checks, you'd have thought that, fine, clean register, perhaps we can move on from there. But it doesn't appear as though that is the case, because CUPP raising some concerns as well about integrity of that register. Well, first of all, tell us, if those concerns are perhaps minimal percentage in that register, do we expect 100% cleanup? And does it, to what extent does it raise questions about integrity of the voter register?
Good morning, Chamberlain. Thanks for having me. As our continuous collective efforts to educate Nigerians, to clear misinformation on how to deliver the electorship of our country to a safe harbor next month. Now, around the world, the credibility of any election is predicated on the existence of a credible register. Beyond a few things that you have mentioned, today I can tell you and entire Nigerians that the register of voters that INEC has at the moment is a very credible register. To the extent that a few things that have happened in the law, changes that are taking place, are such that the observation which is genuine, clearly made by the CUPP, the good news to the people of Nigeria is that those statutory provisions that would have supported some of these individuals that whose name appeared on the register, that was in the time past could have been used to torpedo the process, are all over. For 20 years, Chamberlain, it took us 20 years to repeal Section 49, Section 53, as well as Section 65 of the old 2010 Act. These were election rigging statutory provisions. Today, the INEC register you have at the end of the election, in every polling unit, a new register will emerge, irrespective of the total number of registered voters, because under the current law, Section 47, which now replaced Section 49, the rigging provision that gives power to an untrammeled power to a presiding officer in the past, it is gone forever. Section 51 now, that before now you hear about total number of registered voters, you hear about inconclusive elections. That provision have now given way to Section 51, which means that today, in this forthcoming election, computation will now be based not on total number of registered voters, but on those who actually came, who were accredited. Now, this is where we are at the moment. And of course, the last section, Section 65, where people used to...
Mr. Igini, before you move on to that Section 65, let me play this for you to listen, because, I mean, my colleagues also spoke about this yesterday, new concern. Many would have thought, for senior advocates to be on this matter, you would have thought, oh, wait a minute, what again with this one? So listen to this, and then we'll take it from there.
The returning officer is not a court of law. The returning officer is not a tribunal. The returning officer is not vested with jurisdiction to exercise judicial or quasi-judicial decision or to assume jurisdiction over any matter that is judicial in nature. When election is conducted, a returning officer returns or makes a return. Immediately thereafter, depending on the number of days, any aggrieved party goes to court, not to determine, not go back to the returning officer that has made a return. By that section, you are given a returning officer and by extension INEC to do and undo.
So, Mr. Igini, let's jump right to it. Take a look at section 65, which has to do with decision of returning officer on ballot paper. So, 65(1), the decision of the returning officer shall be final on any question arising from or relating to A, unmarked ballot paper, B, rejected ballot paper, and C, declaration of scores of candidates and the return of a candidate, provided that the Commission shall have the power within 7 days to review the declaration and return where the Commission determines that the said declaration and return was not made voluntarily or was made contrary to the provisions of the law, regulations, and guidelines and manual for that election. Do we have any concerns for
Thank you, Chamberlain. An old woman is not old when it comes to the dance she knows. And I need to provide a very short context to what the learned Sikh have just said. In fact, I tried to call him since yesterday when I saw these clips to have engagement with him to understand the reason behind that provision. But I think that Nigerians are all living witnesses for in every elections, how section 68 you now reflect another section 65 with this important proviso, what informed it. But first, it should be noted that INEC is a regulator of election in the Federal Republic of Nigeria, to the exclusion of any other agency. In a fundamental rule of administrative law is that an executive body such as INEC that is saddled with the responsibility to make rules, to administer rules made to it by National Assembly, to carry out its mandates, it has a quasi-adjudicatory power to use facts that are relevant, that are available to the agency to take a decision, even though subject to judicial review. Now, Nigerians recall that when I said 20 years, it took us 20 years, Chamberlain, to get to where we are now with respect to this particular session. Because this is one of the supporting sessions for election rigging in Nigeria. A returning officer, first and foremost, this provision is talking about returning officer, not a presiding officer. INEC as a body have not reviewed a decision by a presiding officer. We are not talking about presiding officer here. A presiding officer is actually where decisions of the Nigerian people are made, expressed through the ballot. The job of a collation officer at the world level, local government, is to collect the views, the decision of the people as expressed in the ballot. But what we have over the years, a returning officer, a doctor, a professor will appear, reappear, disappear, and declare people to win as winner of election. And that is why I've sent something to Channels Television, if you can put it on. At the moment, INEC, this is not the picture. INEC has what we call is a center that is domiciled in the entire state. We call it Electoral Operations Support Center. You have it in each state of the federation, where they track the movement of materials from central bank to INEC office to the local government to the rack center to the polling unit, and from the time of the opening of the poll, where INEC is already seized of the wrongdoing going on at any point of collation, INEC has a responsibility first to be debriefed by the returning officer as to what had transpired. Now, once INEC has found out that the result to be declared is illegal, not voluntary, it's being done under gunpoint, as you saw, even in 2019, many people have been returned to office.
Yeah, so
through some
Mr. Igini, a number of things there. So when you say that speaks to the returning officer, not the presiding officer, who you say determines what transpired, is it that presiding officers do not rely on returning officers to do what they have to do, or is it immaterial if Mr. Olanikpekun's point is that if you're aggrieved, you should not be going to returning officer whatsoever? It should be recourse to the judicial process.
With the greatest respect to the learner's sake, he did not understand the background behind that provision. With the greatest respect to him, any suggestion that we should go and amend the current 2022 Electoral Act that have not been implemented fully is a recipe for something else. The whole design of the electoral process now is to end the business of election tribunal in Nigeria. Why should we ask people to go to court? For example, look at Peter Ogba, who has been convicted. He generated results, figures that are not consistent with what happened at polling unit. The tracking system got that, and everything was put on hold. Take note, it is not the presiding officer, the returning officer himself that will make that review. It is INEC that have the power to do that review within 7 days before a return, if any, could be made with respect to that particular election. That is what we are saying. It's also subject to judicial review. It has not stopped the court. It doesn't stop anybody from going to court. But first and foremost, administratively, INEC should be able to take that decision without people having to go to court. That's the reason in Nigeria, those who rig elections are the ones to suggest to you that go to court. Go to court. We must be careful, because in England, where we borrow some of these things from, time there was when election rigging was an issue. Such matters were taken to the House of Commons, petition to be determined. Right there, there was no electoral justice. It was now decided that the matter should not be taken to the courts. By the time they got to the courts... No, let me just land on this. All right? The decision was not taken in England. I should be taken to the court. When they got to court,
Mr. Igini, if I may come in here, because time is fast spent, if I may come in here, sorry to interrupt your thoughts. I don't want to ask you 2 quick questions, but I know that you can handle the 2 of them at once. One, I think that, perhaps what Mr. Olanikpekun is afraid of here might be abuse. Do you think that this provision of the Electoral Act, do you think it could be subject to abuse? Even though we're trying to cure one form of abuse we've seen in the past, do you think this can be amended? And then it's a very ambitious plan to try to want to, do away with election petition tribunals. You do know that a lot of lawyers look forward to that period. I mean, do you really think that that will go away without much of a fight?
But we shall end the business of election tribunal in Nigeria. You see, the book of lamentation is not written because of Nigerians. We shall end that business. Look, this section has not ended, this section in question that is totally misunderstood by the learner's sake and perhaps any other person out there. It has not stopped anybody from going to what they call the tribunal. It simply says, and I don't want to mention names, there are several names, and I have video clips of how on gunpoint people were made to make what we call a declaration. Have Nigerians forgotten what happened in 2019? Are we suffering collective amnesia in this country? That people were declared on gunpoint, not voluntary, not consistent with the procedure. You know, part of the problem people don't even understand, Mark, is that the current system that we have now have actually taken care of this likely scenario that people talk about. Because at the polling unit now, which that is center of universe, this is where election will be won and lost. And the fact that political party, INEC is now doing what we call the broadcast of that result, send it to the cloud, put on the IREF, everybody can now see the result. It's even going to be difficult for any returning officer. Don't forget that the job of a returning officer is ceremonial. The cases we had in Akwa Ibom, for instance, was a clear case where what happened at polling units and under the EOSC system that I said you put up for Nigerians to see, we already knew what happened in those particular constituency. Only
I think my question is, are you saying that this is foolproof? Is this really foolproof? That's the question.
The system we have right now?
Yes, as the new provision of the Electoral Act.
The system we have is very robust. It has brought tremendous energy of hope, of integrity. Look, Mark, I have never been as hopeful about our election before in this country under this time. Because those statutory provisions that will be fighting for 20 years, Mark, for 20 years, that they were reluctant to change. Somehow, the National Assembly members, they had the Damascus experience, and they now changed the law. And I thank Mr. President for signing. Don't forget that for about 4 times before the 2019 election, efforts were made. It was a failed effort. The reality of that failure before 2019 election that had now been signed into law is what we are seeing today. Mark, let me say this here. With respect to the CPP, talking about the register of voters, the thing you need to know about this register of voters is that all those names of Jamaicans from New Zealand, anywhere around the world, the INEC staff that were responsible, because for every registration today, it is done by INEC staff using their personal ID. They have been identified. I am sure that by the time they are facing what we call the APDC committee, as I'm told at the moment, by the time INEC is done with those category of people, not less than 30 to 40 staff of INEC will have to lose their career. And my further recommendation is that not only dismiss from the system, they will also must be arraigned and jailed for doing something that undermines the integrity of the process. Now, for the register, Mark, let me say this here. A few things that we need to know about this register. Clearly, from the demographics, it is very clear that those between ages 18 to 34, 35 to 49 are going to be those who are going to make the determination, because there are over 70 million out of the 94.5 million registered voters. Number two, that must be noted is that this register total number is not going to change before the election. On the election day, that figure remains fixed, as opposed to political party register.
Well, Mr. Igini, just to be clear, right? I think one of the arguments, my apologies for butting in, just to be clear, I think the challenge that's being posed here, for which reason Markwe is asking whether or not it's foolproof, is in that provision itself. It says that the commission shall have the power within 7 days to review the declaration and return, where the commission determines that the said declaration and return was made voluntarily or was made contrary to the provisions and all of that. So I think what the learned silk, as you call him, is referring to is, okay, so INEC can make a declaration and then within 7 days review its own declaration. Those who will be wondering, hey, what's happening here? For instance, he also cited the example like the INEC chairman
is the chief returning officer for the presidential election. He is the one that is going to make that declaration. So if after 7 days he comes back and says, my declaration, my initial declaration was wrong, I'm reviewing myself, there's going to be some questions.
No, it's totally, but this analogy is totally off the mark. You understand? But I know you want to interrogate further the issue. And let me now explain to you. You see, these are not a very common thing during the election, but we have isolated cases where at the polling unit, and I just said we have a tracking system. We have what they call the Election Operations Support Center. And at the Abuja level, you have the EMLSC, Election Monitoring Support Center. It is based in Abuja. It gives INEC what they call 360 visibility view of what happened. But here is what you need to know here. It is that if we have been tracking, we are getting the results, just as the people of Nigeria now begin to see the upload, like those elections, 2 million viewers were allowed, whether you are in Japan, New Zealand. What we are now saying is that if from the polling unit, everything has been computed, well, we get to the Work Collation Center, and at the Work Collation Center, suddenly the returning officer disappears. We are talking about those who disappeared that you could not find on that day. Suddenly making an announcement somewhere, they go underground. We put it on hold. You put it on hold, he will now be eventually, we'll try and get him, invite him, and so that we can put all the documentary process, all the whatever polling unit, put all the results together. How did you arrive at this? How can you say that the decision of an agent, somebody you appointed, don't forget, look at that section. It says, whoever we have appointed, whatever he declares, whether it's illegal, illogical, unreasonable, is final. It cannot be final until, in such situation, INEC within 7 days, calling all stakeholders together, putting all the facts together to say what you have done is wrong, what you have done is right. That is what we are saying. And it's not just too common, but we have had situations, many, where people were under gunpoint made to forced to make a return that is illegal, that is not consistent with the provision of the law. That is what we are talking about.
Well,
let me warn here,
Mr.
the
Igini,
danger of going to National Assembly now. If you go to National Assembly now, those who are opposed to certain reality now, brought about by the current act, will take advantage of that.
Mr. Igini,
is the graveyard for contending opinions.
Mr. Igini, does subsection 2 of the same section 65 perhaps answer Marquez's question of whether it is foolproof or not? And this is what he says: a decision of the returning officer under subsection 1 may be reviewed by an election tribunal or court of competent jurisdiction in an election petition proceedings under this act. Does this create room for litigation, perhaps when a candidate, if and when a candidate raises an objection to a review of INEC done by INEC after the declaration of the result by a returning officer?
Bukola, what we are saying here is this: the fundamental principle of administrative law, that an agency, saddled with a statutory mandate, has the power, primarily first, to take a decision. That decision is subject to judicial review. That's simple. So if a Professor Ogban, who has been convicted for 3 years imprisonment, and another one is standing trial, particularly that of Peter Ogban, who uttered figures different from what his own colleagues has computed at the level, at the ward level, but at the senatorial level, he uttered the result. Evidence was clear. And that was why in Akwa, but they could not make that return. Because using the tracking system, we were able to halt that process and put everything together before a return was made. That is what we are saying. All this idea of telling us to go to court, go to tribunal. Jonathan Sumption, the retired Supreme Court of England, warned when the matter went to court that, look, the moment you take almost all political matters to court, there will be struggle by politicians to control, to take over the court.
Well, Mr. Igini, the question is quite simple. Empire. Just a second. The question is quite simple. Are you saying that whatever decision INEC made is final and so completely final, even after its own review? Just a second. Or that you're saying, because you also mentioned earlier that we want to see how we can eliminate the courts or tribunals taking the decision as opposed to the decision of the people, which of course would be based on some of the resolutions made by INEC, or rather conclusions, made by INEC from the voters, from the decision of the voters. So when that subsection 2 of 65 says that the courts or the tribunal can review it, what does it mean in the context of what we are talking about now? Especially when you say, I want to try to eliminate the role of courts being so predominant.
I'm not saying that courts will not have a role in our judiciary, because democracy is based on the rule of law. It is the duty of judiciary to interpret the law. But we are saying that the process and procedure that are put in place now are such that, as we would have seen in recent elections, nobody is challenging the outcome of the process itself. Most of the matter that were taken to court in all the governorship elections we conducted recently, apart from perhaps Oshu, which I don't want to talk about for now, they were all based on issue about certificate, not having certificate, not having the proper nomination and all that. We are now saying that when we get to a point where we are already trying to consolidate now, that at the end of election, there will be no need for people to want to go to tribunal. And that was what happened in England. When they went to start going to court, they now discovered that politicians were also now trying to corrupt judges in England. The decision was, okay, what do we do? The decision was that make the election more transparent. Adopt this secret balloting system that was discovered in Australia and was applied in 1856. It took England up to 1872 to adopt secret balloting. When secret balloting was done, there was improvement in the standard of living of people of England. It was no longer possible for people to modify a ballot as a means of livelihood, but rather the ballot became an instrument to choose the best candidate that can address issues that concern the people of England.
Okay.
That was what turned trajectory.
So
we must stop the expansion of the empire of the court on matter that can be dealt with. Why should we, Ayo?
Well, that is understood. My apologies, Mr. Igini. As Markwe told you earlier, we're really running against time. But also speak to the concerns of Mr. Bakuba, concerning Section 134(1) and perhaps 2 as well, which speaks to when he says that the Constitution is talking about 2 languages. Just for clarity, we know that the Constitution, for instance, is clear when it says a candidate for an election to the office of President shall be deemed to have been duly elected where being only 2 candidates for the election has the majority of votes and has not less than 1/4 of the votes cast in all states, in at least 2/3 of all the states and the FCT. And the second one says a candidate for an election to the office of president shall be deemed to have been duly elected where there being more than 2 candidates for the election, has the highest number of votes cast and has not less than 1/3 of the votes cast at the election. So 1 is 2/3, 1 is 1/3, and 1/4 of the votes cast at least 2/3 of the states in the Federation and the Federal Capital Territory. Just for clarity, help Nigerians understand what this is all about.
First, the observation made by the learned Sikh is very apt, and I'm very delighted that he did one thing, and that is that he deferred to the commission. I said he wrote to INEC. This one matters that we don't have the time. I'm going to provide figures, but we don't have the time now. But the question in that subsection is, which is the turning issue try to talk about. Is it that for you, apart from the having 1/4 into 2/3, what is the 2/3? 24, another, and the conjunction there and the Federal Capital Territory, do we mean that for you to even if you have met the indicia provided with respect to the entire state, must you also have a 2/3 in the Federal Capital Territory? That is the question. Or are we now talking about 2025? that we are talking about and not 24. That is the issue. It is the commission that should come out. I don't want to say something on this now. Let the commission turn out. But more important, another aspect, which of course I have made preparation for that, which one of the matters we are going to discuss in the days ahead. In each state of the federation, do you realize that in computing what is called 2/3 of the local government, you have what you call fraction. Now, is commission going to take the upper limit or the lower limit? I have all the figures already, the data already. But again, what is important, I will provide to Nigerians some states that you don't have problem. For example, in Imo State, for instance, you 2/3 of 27 local government. It means you must have that wakuda in 18 local government.
Well,
18.
As you said, Mr. Igini, there is a lot to talk about this, and since the letter was addressed to the INEC chairman, I guess we have to wait. Yes. It's written in English language, and there are certain conjunctions, certain words used in those two sections that one will have to pay attention to. Every Nigerian needs to do that. For now, we have to thank you very much.
But
we have run out of time, Mr. Igini. We know that, we're going to have to call you back another time, so thank you so much for this morning. Mike Igini is a former rec of INEC at Akwa Ibom. Thank you again for your time this morning.